counsel, and now she's she's a trial lawyer. And we last semester in law school we did a class called trial practice, and we broke down the trial starting the word Gordon all the way through. And she and I we drew our side of the case out of a cap actually, and it was the prosecution side of first degree rape in Oklahoma. And first degree rape in Oklahoma is when no, it's not a capital offense, but it's when somebody, but it could be if you have death and you meet some of the other qualifiers, but it's where a person uses a weapon to carry out the attack. Now, if they don't use a weapon, a guy just uses brute force, then it's second degree. Right. And so we did that, and boy, it was great. One of our teachers was a federal magistrate judge, and so we got to do our actual mock trials. Ours, Susan's and mine was the first one. 3 of our classmates defended the defendant, and we got to do it in the large ceremonial courtroom of the United States Federal District Courthouse in Oklahoma City, because one of our professors was a federal magistrate judge, and our other professor was the general counsel for Oklahoma City University, and he and Judge Couch had been, they were part of a defense term. They defended a lot of companies, and so, but it was so cool to do that in the federal ceremonial courthouse.
Down in Memphis, we did ours in the Shelby County courthouse, and back then they still had courts of chancery.
Really?
Yeah, and so we did ours. I did mine in courts of chancery number 6 in the Shelby County courthouse.
Wow. I've never seen any of those, but I've heard of them.
Yeah.
You know.
Well, basically, I mean, the historic chancery was where you go when, you wanted equity.
Right. Right, exactly.
So they still had those in Tennessee.
Wow.
Yeah.
I wonder if they still do or not.
They do, but now they're more like municipal courts. They decide all the same issues as regular courts.
So they do it on a municipal level rather than a state level. Huh, interesting. Well, that probably takes a lot of stuff off the docket for the state courts then. Because I know the dockets are generally quite full.
Well, my third year, I clerked for a guy who did criminal work. They had a program at Memphis State. If you were certified, you could assist in a trial. So I actually cross-examined the doctor in a murder trial in my third year.
Wow, I guess so. Yeah, like they told us in that, you never ask a question you don't know the answer to.
Right.
And nobody to pull the switch up there for you. You show the lever.
Vialo. Thanks. Most of you, I think, are familiar with Vialo. Weiss, he's our in-house counsel, so to speak.
On federal levels. I can't practice law here.
That's right.
Because I'm not licensed here.
We'll leave the actual practice of the law right here.
In Indiana to Chris, yeah.
But we want to thank him for being available today to make this presentation on religious liberties. One of the things that I've come to admire about this man is that he is focused and he really knows what's going on. We've had a few cases over the last 3 or 4 or 5 years. Some of them gotten really involved. In fact, one of them is getting rather involved as I see it unfolding. But religious liberty is not a joke. You want to keep your religious liberty, you better be willing to sacrifice a little bit for it. And one of those sacrifices is right here, right now, and listening to somebody who's really on the firing line on a more practical basis. So I'm pleased to welcome Vialo Weiss, our conference federal representative. You're on.
Well, it's good to be with you guys today. I was at the lunch table there. We were talking about how when I was a junior in academy, I wanted to be a lawyer, and the Lord called me to ministry and wouldn't take no for an answer. And then 30 years later, in 2002, He opened the door for me to go to night school. I was doing plan giving and trust services for the Oklahoma Conference, dealing with religious liberty matters for them, and dealing with property matters. 3 of the 4 things that I do here. And I went to night school for 4.5 years on top of my full-time work. It was brutal, but God saw me through. My wife, Shannon and I both started at the same time in August of 2002. She was a full-time student. We got married in December of 2002 at the end of our first semesters in law school. And she passed the bar exam in July of 2005, and I finished in December of 6. I wanted to enjoy Christmas, so I didn't take the February bar exam. Because if you're going to take the February bar exam, you're not enjoying Christmas. And took the July 7, 2007 bar exam, and by the grace of God passed the first time. It wouldn't have been cool if I hadn't, since Shannon had already passed. You understand? Yeah, she had already passed. Plus, we'd had a couple of classes together in law school, and she beat me both times. And she's a smart lady, and in fact, in corporation law, she had the highest grade in class. And anyhow, but she tells me at the point in time we retire, and quite reasonable, maybe 7, 8, 9 years, something like that, and moved back to Oklahoma, so we practiced law for Daniel and Clarice's education. She tells me that she'll be the senior partner in the firm since she's had her license 2 years longer than me. So, anyhow, well, let's say prayer as we begin today. Father, we thank you for the privilege of being your children, and pray that you will bless our time together today in Jesus' name. Amen. I want to say just a word about the current religious liberty campaign and encourage you to be generous and in that, because it is important. Liberty Magazine reaches thought leaders, and you don't really realize that unless you're out there in that group. In my last semester in law school, Chris and I were just talking about this. I took a class called Trial Practice, and we broke it down, a trial into every segment. And the last thing we did was a mock trial. And Susan Carnes and I were prosecutors in a first-degree rape case. And then 3 of our classmates represented the defendant. And one of our professors was a federal magistrate judge. And she and our other professor, they had they'd for many years been law partners, and they defended companies they're part of the defense bar representing companies that had been sued. Well, anyhow, one night in class, Judge Couch came up to me and handed me Liberty Magazine. She says, "Mr. Weiss, I think you ought to know about this." And I said, "Well, Your Honor," and I explained about how we publish it for thought leaders. Well, we come to Indiana and start working here at camp meeting time in 13. And in early 14, we were up in Chicago at a law school alumni gathering. And Judge Couch is there. She's now dean of the law school. And Shannon and I are drinking our cups with water, and most everybody else has got stuff that has unholy spirits in it. You know what I'm talking about. Revelation does talk about an unholy trinity. Well, anyhow, Judge Couch says, when I was on the bench, I used to get Liberty Magazine. But she said, now that I'm dean of the law school, I don't get it anymore. I said, Your Honor, I will personally see that you get it. And so every year I make sure that she gets it. I make sure my constitutional law professor in law school gets it. I make sure the professor that I had that I took religion and the Constitution from, and some other, one or two other classes gets it. And because people, thought leaders read it. My wife Shannon was involved in Christian Legal Society while I was still in law school, and then we were both very involved with it there in Oklahoma City area before coming here. Sadly, here they don't have a chapter. I saw in some of the printed materials, Chris, before I came here, that they had a chapter, but after we got here, it doesn't exist anymore. But anyhow, Shannon was at Christian Legal Society, and she was Judge Gurich, who at that time was an Oklahoma County district judge. She talked very favorably about Liberty Liberty Magazine at Christian Legal Society in Oklahoma City, and Shannon was telling me about it. Well, now Judge Gurich is Chief Justice of the Oklahoma Supreme Court. Of course, it rotates, but she's on the Supreme Court for the state of Oklahoma. So thought leaders read Liberty Magazine. And I would go so far as to say it's an evangelistic outreach to thought leaders. So I want to encourage you to be generous and support it. For $6, you can send 6 issues to a thought leader. You're hard-pressed to buy 2 greeting cards for $6 at Walmart, right? I paid that much for a Valentine's card yesterday. And it was worth it. It was worth it, but think about that. The impact you can make for God's kingdom. And so I want to encourage you to do that, because it not only makes a difference in terms of reaching thought leaders, but also provides a war chest when we have to litigate cases for members who lose their jobs over Sabbath. I'll talk about a little bit of that today. And you don't go into federal court on a $20 bill, because they retain local counsel, top shelf local counsel, and they choose the cases carefully because you want to have cases that you believe you can win, so you can set positive precedents, because we don't need negative precedents. And so anyhow, well, just a little brief commercial to begin with. I spend most of my time by request of conference leadership in the area of plain giving and trust services, working with our members and their legal counsel on setting up estate plans. Please keep John Williams in prayer. John is a member at Glendale. Was very sick, getting some stem cell treatment down in Florida. Been down there for several months, and we're just praying that the Lord will raise him back up, because we appreciate his ministry to our members, appreciate his legal ministry to the conference. But one of the things that I especially appreciate about his legal ministry to our members is he charges very, very reasonable fees to our members. And it's part of his personal missionary project, he told me. And so we're working right now with another lawyer at his firm, but I just pray the Lord will bring him back. But, I want to encourage you to have an updated estate plan. It's just really, really important. We had a couple that didn't have a will. An attorney drafted for them, so the state's will kicked in. They died in a motor vehicle accident. Young couple trying to plant a church in a county where there was no church. And they put their kids they had 2 boys younger than 5, put them in the car seats, in the back seat of the SUV. For some reason that evening, Mom and Dad didn't put their seatbelts on. Mom was driving, Dad was riding shotgun. Mom accidentally slipped off the road, overcorrected, and when you overcorrect, you usually lose it, and that's what happened. Both Mom and Dad were ejected. Mom died at the scene. Dad died in an ambulance on the way to the hospital. And the biggest fight you could imagine ensued over the 2 boys. Who's going to raise the 2 boys? Ultimately, their father's brother, their paternal uncle's petition to adopt them was granted by the court. And you say, well, that sounds good. But you need to understand that here's a very devout couple trying to plant a Seventh-day Adventist church in a dark county where we have no church at all. These boys paternal uncle has no interest in spiritual things. It breaks my heart every time I think about it. But in a situation like that where a person doesn't have a will, that's why there's one in state law, because what a person has can't sit in limbo. Something's got to happen to it. It's got to be distributed. So please make sure you have that if we can help you. We've had the joy of serving a number of families in this congregation and be happy to serve you. I spend quite a bit of time in the area of religious liberty, less, but a reasonable amount of time there working with our members and Sabbath accommodation issues. And in the summertime, particularly educating city officials on federal law that implicates our student literature evangelists. There's a lot of cities that have unconstitutional ordinances with regard to solicitation, because our kids are not soliciting, they're taking contributions. And there's a difference. There's a very significant difference legally in that. And so I do a lot of educating in that area. I work with our churches, help them in their stewardship program, and then I deal with real property matters. Anytime we're dealing with real property, I deal with that. So being a lawyer, I'm working with lawyers in the first two and the last, so helps me as I relate to them as they take care of our backside. Do you know what the Big Five is? You ever heard that? Do I?
Go to Africa, the Big Five. That's a different.
Yeah. The Big Five is actually the course of action voted by the constituents at our last constituency meeting. It's the focus of what we are to do in ministry in the state. And so I just want to remind you of that. First of all, to cultivate a culture of evangelism in the Indiana Conference. Not so that evangelism is not an event, but a process. Something that is it's what the whole life of the church is about evangelism. Everything we do should be about reaching men and women, boys and girls, and young people for God's kingdom. The second one is to empower and equip every member for ministry. That's one of the things we're doing in the run-up to these meetings this year. You know, we have Bible workers that are training Bible workers in our churches to give Bible studies. We used to do that when I was a young pastor. I still think I'm young, but the calendar's starting to, vociferously dispute that. But anyhow, but I'm glad to see that we're doing that because, when I was a young pastor, I've been a pastor for 42 years, Bible studies were our interest in evangelistic meetings, and we've gotten away from that, and we just send the handbill out and expect the mailman to be our missionary. Now we still need to use them, but there's a lot more personal work we need to do. We want to make sure all of our kids have a Seventh-day Adventist Christian education. Want to have an intentional path where youth and young adults feel welcome. One of the things we see in our churches is we don't have as many youth and young people and young adults as we would like, do we? I was in a church last Sabbath. I was probably the youngest one there, and I'm crowding 66. April, I hit 66. And when you have a church like that, a few deaths, and it's not going to be viable. And that's worrisome. There's no sounds of kids in the church. If you have no kid sounds in the church, that worries me, because you got a church that's dying. And we want to provide avenues by which our pastors and teachers can grow. So those are the 5 areas of focus voted by the constituents that we are accountable to work in. And then the plus is the preparation that we're making for the run-up to the General Conference session. And we're just about ready to get on the treadmill that we're not going to be able to get off of until July 4 is over. That's why Julie retired. She said she'd been through one General Conference, she wasn't going to do another one. And we're already getting some calls. People wanting us to come pick them up at the airport and put them up. That's a different world. What are you going to do about that? We don't. It's not like we run a hotel. We're a church, so we're trying to work through that. But some people just show up and expect to be provided for. Anyhow. The Seventh-day Adventists, we like to focus a lot on the signs of the ends, and I've noticed this for a long time, and that's okay. It's not unimportant that we focus on the signs of the end, but more important, way more important than the signs of the ends, is the fact that we've got a few billion people that still need to know about Jesus. We talked about that this morning, didn't we? And that's more important even than the signs of the end. So I hope that we will use those signs to encourage us to be about our mission. Freedom as we know it in this country is a complex thing, because it really goes back to the experience of many of those who came to this country, came from the old world, came from a world in which there was persecution. And you remember even in that world, those persecuted, like the Puritan separatists that started the Massachusetts Bay Colony, persecuted in the old world, became persecutors in the new world. The way they treated the Quakers and some others there was just, in the name of God, was just unbelievable, unbelievable. And so it was a very, very complex thing. You have established churches in most of the colonies, and that carries over into our country. And of course, we begin under Articles of Confederation, which didn't really prove all that workable, and so we came back to do a constitution that was sent out for ratification, and people said there's not enough guarantees of our rights. And the politicians said, ratify it, we'll give you a Bill of Rights. One of the few times the politicians really followed through. Providentially, we had greatness to spare at that time, and I believe that was in God's providence. And they came back with the Bill of Rights. And of course, the first one focuses, if you don't have freedom of religion, you really don't have any freedom at all. And one of the things, too, that they wanted to put an end to is established churches. Now, George Washington and company were fine with established churches in the colonies, now states, as long as there was no national establishment. Jefferson and Madison didn't want established churches in either. And at the beginning of the day, George Washington and company carried the day. And then we gradually came to Madison and Jefferson's position. So look how carefully the First Amendment is worded here. It says Congress. Well, where's my laser? There it is. It says Congress. It doesn't say the Virginia legislature, Massachusetts legislature. Congress shall make no law respecting an establishment of religion. It cut both ways. Congress couldn't say anything about Virginia's established church or Massachusetts' established church. And neither could it say, well, we're going to make the Congregational Church, or we're going to make the Episcopal Church, the national church of the United States. It cut both ways. And over time, the established churches in the states went away. Massachusetts being the last, probably sometime in the early 1840s. Around the time, what else is happening? The Advent movement is being born, isn't it? William Miller comes to believe that Jesus is getting ready to come. Interesting. In spite of that, in spite of the history of freedom religiously, and probably most states have free exercise and establishment clause provisions in their constitution. In spite of that, as a practical matter, there wasn't a lot of protection for people of faith, particularly in the employment sector, until recent years. In the Sherbert case, which arose out of the textile industry in the Carolinas, Mrs. Sherbert worked for a number of years in the textile industry. She became a Seventh-day Adventist. She continued to work in the textile industry, and her work was only Monday through Friday. But then her employer decided to add Sabbath. She refused to work. She was fired. She applied for unemployment. It was denied. Her case went to the Supreme Court, and the Supreme Court adopted the compelling interest test to deal with cases like this when you're dealing with various issues. How do you balance these issues? And I love the compelling interest test because it's a very, very high bar for the federal government to have to meet. The law must be narrowly tailored. Can't be a broadly worded law. It must be narrowly tailored to achieve the government's compelling interest, and government action must be the least restrictive way of furthering a compelling government interest. In other words, for government can restrict my religious practice, there has to be a very strong showing that this is the least restrictive way of doing so. And I want that burden on government because they almost never reach it. That was the law until Smith, the peyote case. This is a consolidated case. Mr. Black and Mr. Smith were Native American drug counselors in Oregon. They were required to sign a statement that they wouldn't use drugs. Not unreasonable to ask that of a drug counselor. But then they used peyote in the Native American worship service. The use of peyote was illegal for any purpose in Oregon at that time, religious or otherwise. They got fired. They thought the free exercise clause would protect them. Case went up to the Supreme Court, and Justice Scalia, who, by the way, is not a friend of religious liberty, wrote that the generally applicable laws don't violate the free exercise clause. So you can see how that does all kinds of violence to the compelling interest test, doesn't it? Sorry, we're not going to cut you any slack. Because see, in Oregon, nobody could use peyote, religiously or otherwise. And so he said, sorry, we're not going to cut you any slack. And so, the last presidential election cycle, people were saying we needed somebody like Justice Scalia back on the Supreme Court. At the end of the day, I would say no, because Justice Scalia was not a friend of religious liberty. He did throw us a bone at the end, but a little late. And but I wouldn't want somebody like that. He was also a very ardent supporter of Sunday laws. Very ardent supporter of Sunday laws. He suggested that maybe we needed to have a legislative solution, so the Religious Freedom Restoration Act was enacted in the first Clinton term. And by almost a unanimous Congress, I think there was only like 3 votes in both chambers of Congress against it. Now that does not happen very often. And it sure doesn't happen today, because I've never seen Congress so divided along partisan lines as they are today. It's really sad. And so that was the law really just for 4 years until Bernie, a case involving a historic Roman Catholic church on the far north side of San Antonio. Its building was on the National Register of Historic Buildings. And when you have a building on the National Registry, you don't mess with it except maintain it. You don't then change the footprint. You maintain it according to certain rigorous standards. They wanted to enlarge it. The case went up to the Supreme Court, and the Supreme Court ruled in Bernie that Congress's enforcement powers on the state Congress had exceeded it in imposing RFRA on the states, and so now RFRA only applies to the feds. No compelling interest test on a state level. Hobby Lobby case comes along. It involves 3 companies. Hobby Lobby, which you know about. Mardell, which is owned by the same family, the Green family out of Oklahoma City. Mardell is like a Christian office supply store, but you can also buy Bibles, buy music there, but all your normal office supply stuff too. And Conestoga Wood Specialties. And the 2 owners of these 3 companies said, we're opposed to offering the 4 abortifacients required under the Affordable Care Act. We have a conscientious objection to the morning after pill, if you please. And they sued because the Affordable Care Act was requiring them to do that, because the federal government couldn't show that requiring them to offer those 4 abortifacients in their health care plans was the least restrictive way of furthering a compelling government interest. The feds lost. That's Hobby Lobby. That's why I like the compelling interest test, because the feds don't do very well with it. We tried to get back the compelling interest test under the Religious Liberty Protection Act. Nick Miller, who's our Lake Union Parle director, he's also an attorney and now a PhD in history, teaches at Andrews and also helps us in the Parle department at the Lake Union. We had, by that point, you had the growing political power of the LGBT community, and so the best we could do was the Religious Land Use and Institutionalized Persons Act, which restored the compelling interest test in these two particular areas. And here on the second part of it, the Institutionalized Persons Act, Mr. Holt, who's as Caucasian as me, becomes Muslim, and he's in Arkansas prisons. And he wants to grow a beard in accordance with his Muslim faith. But he's willing to compromise and only grow a half-inch beard. But the state won't let him grow the beard. They said, you know what, we may have trouble IDing you. And furthermore, you could hide contraband, in your beard. Justice Alito at oral argument said, well, you search a prisoner, why can't you comb his beard? And because the state of Arkansas couldn't show their ban on beards in Arkansas prisons was the least restrictive way of furthering a compelling government interest, Mr. Holt, whatever his Muslim name is now, can wear his half-inch beard in Arkansas prisons. But seriously, how much contraband can you hide in a half-inch beard? Not much, can you? Not much. Again, that's why I like the compelling interest test, because the federal government and even state governments in this case don't generally meet it. So how do you have the compelling interest test on a state level? Well, you've got to have a state RFRA, or you have to have decisions by appellate courts in your state giving you heightened protection. And I don't think we have 20-some states that have RFRAs, but Indiana's, Arkansas's, and Mississippi's were the last three that were enacted shortly after Hobby Lobby, and I don't think we're going to see any more because they're now perceived as being discriminatory. You remember the firestorm we had here in Indiana. And the reason for that firestorm was there was a provision in that act as originally enacted that contained language stating that it could be used as a defense if individuals were sued. For example, Chris, let's say you had a florist shop and you decided that you had a same-sex couple come to you and you refused to do flowers for their wedding and they sued you, you could claim the act for defense. The problem was, and this I think is a very strategic mistake that the proponents of our act here in Indiana made, was they should have followed the government RFRA, which dealt with government burdening religious practice, not other parties. That was the mistake they made. And if they wouldn't have done that, it wouldn't have been cast in such a discriminatory light. Because you remember wasn't there a pizza place somewhere here in the metro area that said that they wouldn't serve to a same-sex couple, and that got all kinds of press, and then people from other states were not wanting to let anybody travel here because we were going to have this discriminatory law, but they already had a RFRA on their state books, which I thought was a little bit amusing. They didn't even realize it, some of those states. The act eventually got changed to getting back to just government burdening and some protections for us, but we didn't even need to go there. People, you couldn't discriminate based on sexual orientation here, and so it was a strategic mistake that the proponents made. And I wish they wouldn't have taken that approach. They should have left it like the feds were. I wrote a very interesting article on NPR last year, and the title is what caught my attention: How the Fight for Religious Freedom has Fallen Victim to the Culture Wars. And we've been seeing the culture wars go on some time. The liberals of whatever party, it doesn't really matter, politically liberals when they started pushing for increased rights for the LGBTQ community, the conservatives said, hey, we can't be forced to accommodate something we don't believe in. And the liberal response was, well, that's discriminatory and even illegal. And the bottom line is, liberals used to be the champions, generally, of religious liberty. Not anymore. Because they see our willingness to not accommodate things we don't believe in as discriminatory and illegal. So we've lost a very important and powerful ally in those that are liberal politically. Doesn't matter what party, liberals politically. So that's one of the challenges that we face today. And we're going to see that play out as we get closer to the end and in some other ways too at the present. We've had a number of Establishment Clause cases. It's been a while since we've had some, but we've had several of them recently. The first is the Bladensburg Peace Cross. It was erected to honor World War I dead from Prince George County, Maryland. And somebody was offended. That seems to be the operative word in our culture today. Somebody gets offended. And so suit was filed alleging a Establishment Clause violation. The Bladensburg Peace Cross, and of course this is a big one, you just saw the picture there, but the Bladensburg Peace Cross, let me go back just a second, is a Latin cross. And it's that type of cross that's on the graves of our soldiers that are buried overseas. Are we going to go chisel that off of all those tombstones? I hope and pray not. Anyhow, the Supreme Court ruled that it didn't violate the Establishment Clause because it was not erected as a religious symbol. It was erected as a symbol for the World War I dead from Prince George County, Maryland. By the way, you're probably aware of the fact that most of our soldiers in World War I and World War II who died on the battlefield are buried nearby over there. There's very few that are buried here in this country. Very, very few. I have an uncle that's buried in this country, and that's simply because he died in the Philippines. No bullets, just got sick and died. But they moved the cemetery after the war, and my grandmother was given the option of have his body reinterred in the new cemetery or have his body shipped home. She opted for the latter. And so even though Shannon and I are here in Indiana, we still go down every year and put flowers on his grave. My grandparents, he's buried there beside my grandfather, my step-grandfather, my grandmother. We put flowers on the grave, one of those white marble tombstones. And so, you know, he is and I think that was a good ruling. I'm not a strict separation. If I were, I'm careful, but again, I'm not a strict separationist because if I were, I would be opposed to "in God we trust" on our currency, and I'm not willing to go there. That's not a mountain worth dying on. You know, not every mountain is worth dying on. We have another cross case that they hope the city of Pensacola hopes Supreme Court will take, because this was one that was erected in 41 in the park there. You know, the JCs are like the Lions and the Rotary, you know, Public Service Club. And they've lost it apparently at every level, and they've appealed to the Supreme Court. I don't know if the Supreme Court's going to grant cert or not. We'll see. Now, this is a very interesting case that was argued the 22nd of January. So it's just, you know, we're just about 2.5, 3 weeks, you know, in the rearview mirror here. The Espinosa case out of Montana. This is a case where in 2015, the Montana legislature adopted a state tax credit that you could get for every dollar you gave as a taxpayer up to $150, you could get a state tax credit for that. It would come off of your income tax liability, in the state of Montana, up to $150. If you contributed $150, it would go into a special fund that would support low-income children who wanted to attend private schools. So, in a sense, you don't have any public money because the money here is actually all from citizens, but you do have the state receiving tax dollars here. So anyhow, in 2018, the Montana Supreme Court struck it down because the Montana Constitution forbids direct or indirect support for any sectarian purpose. If I say the Blaine Amendment, does that ring any bells with you? I see a few heads shaking. The Blaine Amendment was an attempt to enact a national Sunday law in the late 19th century. And it failed. A lot of it was due probably to the work of our church and some others. Religious liberty work was really, I guess that really birthed the religious liberty work for the Seventh-day Adventist Church, arguing against the Blaine Amendment. But you have, in a number of states like Montana's, you have a reaction to that, and they call them Little Blaine Amendments, where no support directly or indirectly for any sectarian purpose. There were a number of these because there was a lot of anti-Catholic sentiment still at that time. And so that's probably what led to this constitutional provision. The issue with Espinosa is here you have direct aid. You know, this scholarship money comes directly from the state to the school. Now, there's an argument to be made, it's not state money, it's money donated by citizens, but then you also have the fact that the state gave up collecting tax dollars to it. So it's a little bit of a mixed deal. And like I said, oral arguments were the 22nd of January. Now, the issue is we have a couple of cases that cause some tension here. You have the Trinity Lutheran case. And this was a case where Trinity Lutheran was discriminated against receiving public money to redo their playground area with recycled materials. And the Supreme Court, in a footnote in the Trinity Lutheran case, said, we are not finding this case to be an Establishment Clause violation, but we're not commenting about any future cases. They just found that one not to be an Establishment Clause violation. Direct aid from the state to redo their playground area at the church with recycled materials, but direct aid. Generally, that's been an Establishment Clause violation. And then you have Zellman, which is the case that found that vouchers are constitutional if they go to the parents, not to the school. Because the earlier voucher cases, they were found to be Establishment Clause violations because the vouchers went directly to the school. You have direct aid because it went to the parents, and the parents could choose private school, religious, non-religious, they could choose. Then in Zellman, the Supreme Court found that was indirect aid. So the Espinosa case is really in the play of the joints between these two cases. And it's going to be interesting to see what the Supreme Court rules. You know, a little bit of the tension between the Free Exercise Clause and the Establishment Clause. And we also have to recognize that these rights, while they're important, are not absolute. They are not absolute. The court has never granted absolute rights in these areas. There's I can't even pronounce the name of it, but I remember studying it, and you probably studied in con law too, Chris. There was a case that arose out of Florida. It was some island religion that they offered animal sacrifices. Yeah, and but there's a funny name to it. But I think it was the Santeria religion, and the Supreme Court ruled that they could continue to do it in spite of a local city ordinance that forbade it. So if you had in the Old Testament, clearly there were times when people offered child sacrifices, right? And the Supreme Court's not going to grant that right. That's a slam dunk. So these rights are not absolute. So there's tension here, and it's going to be interesting how they rule on this case, because generally they have been opposed to direct aid. Trinity Lutheran is the only one that they have made an exception for. Somehow they felt they were discriminated against them. So I don't know, that it is going to be interesting to see how that one comes out. Zellman, that's the reason why our vouchers here in Indiana are constitutional. Because it's in direct aid, it goes to the parents. And I'm not opposed to vouchers as they are now, because I'll take any year that we can get a kid in a Seventh-day Adventist school. I'll take that hands down. Now, the time may come when we got to say no, because there's some strings that will be attached to it. But for now, I'll take every year we can get one of our kids in our schools. And in fact, truth be told, Indiana Academy would probably not be open except because of vouchers. A significant number of kids that are there on vouchers. And I'm glad they're there, getting a Seventh-day Adventist education. But if vouchers go away, the only way I think we could support Indiana Academy is we'd have to lay off probably at least a third of our pastors. And I don't think our churches are going to stand for that. Because most churches I know would like to have more pastors. Am I right? Yeah, right, exactly. Let's look at some employment stuff. This is an interesting one, the Janus case that arose out of Illinois. He was a non-union employee, a state employee, still had to pay a $45 a month agency or fair share fee to cover collective bargaining costs under a case that arose out of Detroit 30, 40 years ago. He felt that was forcing him to endorse speech he did not agree with. Supreme Court bought that argument, and they ruled, we conclude this arrangement violates the free speech rights of non-members, compelling them to subsidize private speech on matters of substantial public concern. So any non-union employee, any public non-union employee that has to pay agency or fair share costs now no longer has to do that. Of course, the labor unions were not very happy about that, but I still agree with the case. I think it's a good one. The Abercrombie case is an important case because it was this was a case where a young lady applied for work at Abercrombie & Fitch Kids that wore a head covering, teenager. And of course, Abercrombie & Fitch is a little bit on the risque edge of fashion. And so I'm not surprised that they declined to hire her because I can't imagine them wanting somebody with a head covering. Can you imagine that at Abercrombie & Fitch? I can't. And so they didn't hire her, which was a Title VII violation because all she had to show was a need for accommodation. That was a motivating factor not to hire. And they affirmed that Title VII doesn't demand mere neutrality, but rather an affirmative duty to accommodate, unless it's an undue hardship. EEOC has won several judgments for our members, and we're very grateful for that. They settled, litigated, and reached a settlement in late 2019 in the case of an Indiana member down at Seymour, of our Seymour church, who lost his job over Sabbath. And so your religious liberty offerings go to help in cases like that. Also, we litigated more recently the case of two church members who lost their jobs at a Kellogg's cereal factory plant in Utah. Of course, long ago, Kellogg's was Adventist, but that was long ago and far away. And the federal court in Utah ruled that Kellogg's policy of using vacation and swapping with others was enough. They didn't really have to resolve the conflict. The 10th Circuit ruled for accommodation to be reasonable, you have to resolve the conflict. And I'm glad they got that one right, because they messed up in Abercrombie, and the Supreme Court had to take that one and clean that mess, the mess that they left. And this is one I just ran across in the last few months here, a Sunday keeper who refused to wash dishes. Look at what the EEOC got for her. Now, this is not going to stand, especially the punitives. 21 mil in punitives? You know, if I'm a member of the defense bar, I'm going to be appealing that in a heartbeat. Now, she's going to get punitive, but she's not going to get 21 mil. That would be quite a payday, wouldn't it? But that's not going to stand. She's going to get something. But so that's very helpful. Now we just learned recently that Supreme Court's granted cert, and that means they certiorari, or we call it cert, in two cases where for two different teachers at two different Catholic schools in California. One of them is alleging age discrimination after a contract was not renewed. The other is alleging an ADA claim as the school didn't renew her contract while she was being treated for cancer and subsequently died, and her husband's prosecuting that case. And both of these will implicate the ministerial exception doctrine under Hosanna-Tabor. So, because under Hosanna-Tabor, the Supreme Court ruled we have the right to hire and fire who we want to in our schools, in our churches. We can't be forced to hire people that we don't want to have working for us, which I agree with. So it's going to be interesting, because see, we have courts, and in this particular case, the Ninth Circuit is saying that most of what they're doing is secular, it's not religious. Well, I'm sorry, in our schools, whether teachers teaching math or history or English, I want them teaching it from a biblical perspective. And I don't see how you can divorce religion from a, quote, secular subject, end quote. And so that's going to be part of the challenge there in this case. So it'll be interesting to see what happens here. We also have the Daryl Patterson. It's before the court on an application for cert. He was a trainer for Walgreens. He lost his job. And some of the justices have indicated an interest in looking at the de minimis rule from Transworld Airlines v. Hardison, which what the de minimis rule does, it basically doesn't make a company have to make much of a showing, just a minimal showing, before they can say it's an undue hardship. And so if it's an undue hardship, we don't have to accommodate you. We've got a case. I saw it first in the Lake Union Herald. Didn't you get the Lake Union Herald by email? Yeah, you can get it by paper, but you can also get it by email too. And I saw they do a weekly thing, and I saw in there where a guy at Walmart in Wisconsin, he was promoted, going to be promoted to assistant manager, and then they rescinded the offer because they wouldn't accommodate him. They wouldn't accommodate Sabbath for him as an assistant manager. And then I saw it in the NAD news notes since then. So that's why we're hopeful that they will take his case, because they need to deal with that de minimis rule from there, because companies need to make a little bit more of a showing before they can legitimately claim it's an undue hardship. And that's a little bit of the situation with our friend there in Wisconsin, this same issue. That's why we're hoping, of course this is going to be down the road, but still we're hoping that it will happen. He worked for them for 6 years. And Todd was telling us at a North American Vision Attorneys Conference last September or October down in Florida that they didn't expect to lose both at the federal district court and the circuit court, but they did. And so we're hoping that Supreme Court is going to take that case. These issues keep coming, the LGBTQ cases. The most recent one that's got a lot of the press, you remember, was the Masterpiece Cake Shop case out of Colorado, where Jack Phillips refused to do a wedding cake. Now, he was willing to sell to same-sex couples, but he wasn't willing to violate his free speech rights to put language on a wedding cake that violated his conscience. And so, of course, they sued, and the Colorado Civil Rights Commission, this ended up being a blessing. They were actually very hostile to Jack Phillips. And state agencies like this are supposed to be neutral and even-handed. They were anything but that. And so that really helped us in this particular case. And what's interesting is, on 3 other occasions, they had ruled for bakers on the other side of the issue who refused to bake a cake with the language opposing same-sex marriage. And these bakers claimed they couldn't do it on the matter of conscience. So, they weren't being neutral and even-handed on this issue, because they should have treated it on either side the same, but they didn't. And the Supreme Court held that they violated the free exercise clause and reversed. But it's narrow because of the facts, but I'll take a narrow decision. At least we got that. But notice what, primarily because of the hostility, but notice what the Supreme Court said. And so this is where you still have a potential of a Pandora's box here. These disputes must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. What I wish they would do is, if a person doesn't feel like they could do it, I wish they could say, would you give us a referral? And they would take that. Because they want to be respected. But respect is a two-way street. And if you don't do it, next thing you know, you're being dragged in court. And that doesn't engender respect. So that's a problem. And of course, Obergefell, same-sex marriage case, it's a fundamental right. Supreme Court ruled. I'll talk about that in a little bit more in another setting here. But it's amazing to me how quickly same-sex marriages become passé. And now it's about who's going to use what restroom or what locker room. The thing that's surprising to me is how disrespectful this is of women. That's what really, really has surprised me. Because I don't know a woman that's got her head screwed on straight that wants a guy thinks he's a woman in her bathroom. And I can tell you as a guy, I don't want a woman who thinks she's a guy in mine either. So, it's a crazy place we're at in our culture today. And it's just really, really crazy. Iowa and Massachusetts, I know, and there are probably some other states that recognize gender identity or transgender, it's another way of saying the same thing, as a protected class. Places of public accommodation can't discriminate. Religious organizations can. They're exempt unless their facilities are used for a public secular purpose. Well, what might that be? Iowa's brochure suggests a polling place on the premises. When I came to pastor the Oklahoma City Central Church in 1991, I learned that they opened their fellowship hall as the polling place for the precinct. And I thought, how wonderful to be of service to the community around the church. But at least in Iowa and Massachusetts, they're not going to look at that as we do as ministry. They're going to look at it as a public secular purpose. And you know who's going to win, right, at the end of the day? The state's going to win. So that's a problem we have in our culture. We have a couple of bills. One that's already been voted, the Equality Act. The House Democrats unanimously joined by 8 Republicans. I want to labor with my Republican representative for a reason I'm just going to mention here in a minute for voting for it, because there's a real problem with this act. Now, I'm not opposed to expanding the Civil Rights Act. I think everyone should be treated fairly before the law. Even people I vehemently disagree with. They should be protected from discrimination in housing and public accommodation. But this is where my concern is, and that's why I'm going to I've got to write a letter to my representative. I'm trying to think what her last name is. Her first name is Susan. Do what? Yeah, Susan Brooks, yeah. This is the main reason I'm really concerned, and then I got a secondary reason. There's hostility, in my view, in the Equality Act because it explicitly excludes RFRA, which means the compelling interest test is not going to apply in cases where religious rights and sexual orientation and gender rights conflict. I don't like that at all. I want the compelling interest test in place before government can burden my religious practice as it deals with sexual orientation and gender identity. The other reason that I'm a writer is I think it's patently unfair for guys who think they're girls to compete against girls in sports. I think it's patently unfair because the fact of the matter is, and God did it this way, but we men have more brute strength than you ladies do. We just do. Now, you ladies are really stronger than us because, like I said this morning, if we guys had to have the babies, the human race would have already come to an end. We wouldn't have gotten to 2020. It wouldn't have happened. So you guys are stronger. You ladies are stronger than us. But this is just patently unfair. And I think it's going to pull down Title IX, which is the equality in college athletics, for women's athletics. There's just a lot of problems here. And it's fine on the one side, but, you need to fix this. Now, in contrast to the Equality Act, now the Fairness for All, and our church has actually been very involved in hammering out this bill. It outlaws discrimination against the LGBT community in most areas of public life, but it expands religious exemptions because of the potential conflicts caused by granting civil rights to them. And it preserves RFRA, which means the compelling interest test. So, but I don't see. Now, I could see that one. I could see Fairness for All getting through the Senate. I'm not sure it's going to get through the House. That's going to be a hard sell to get that one through the House. So, in other words, it's going to be a stalemate. But at least it's out there, and we need to argue for it, and maybe we can get enough people to approve it, that it'll get Speaker can't bury it on her desk, and at least we can get a majority vote, vote up or down. So we'll see. We got another interesting case. This is a free exercise case out of Michigan. Lenawee County. I've not looked that up. Maybe some of you know where Lenawee County is off the top of your head. I don't. But anyhow, the county health department there has harassed the Amish community for years regarding their hand pump wells and outhouses, which they use because of their religious beliefs. What they do, and the way they farm and the way they live their lives and the way they dress, everything is about their religious beliefs. And so the health department there late last year posted notices on all 14 homes condemning them as unfit for human habitation. And in November filed lawsuits against all 14 of the families. And if they prevail in that action, it would result in the demolition of all of their homes. And the result would be an effective elimination of an entire religious community from the county, and it clearly violates the free exercise rights. Now, this is a case where the ACLU is on the right side for a change. They do occasionally get on the right side of a case, I think. They did it with regard to a California law a few years ago that had the potential to implicate hiring people in other academic disciplines outside of theology. You couldn't discriminate. ACLU was on our side of that case, thankfully. And they're on the right side here, and there's another law firm, and I think the county's getting ready to get a big black eye out of this one, because I don't see their action passing muster, but interesting. Now, on an international level, Australia is wrestling with how to promote inclusion and equality with freedom of religion. And thankfully our church is involved there too. Now, one thing that I would encourage you to be involved about, this was actually written about in Liberty Magazine. It's called the Be Heard Project, BeHeardProject.com. This is an opportunity to promote religious liberty international, particularly with regard to the persecuted church. You can be an advocate for those rights. And so that advocacy, too much lunch, that work has resulted in freeing people. And so I would encourage you to be involved. Look at the BeHeardProject.com and be an advocate for the persecuted church. We're blessed in this country, but that's not the case in a lot of places around the world. So take advantage of that opportunity to advocate for religious liberty. I want to look at two last areas. First is the ecumenical movement, and I want to look at it in the context of this statement. When Protestantism shall stretch her hand across the gulf to grasp the hand of the Roman power, when she shall reach over the abyss to clasp hands with spiritualism, when under the influence of this threefold union our country shall repudiate every principle of its constitution as a Protestant and Republican government, and shall make provision for the propagation of papal falsehoods and delusions, then we may know that the time has come for the marvelous working of Satan, and that the end is near. I want to go back to 1999, the joint statement on the doctrine of justification by faith between the Lutheran World Federation and the Roman Catholic Church. And point number 5 is this: the present joint declaration has this intention, namely to show that on the basis of their dialogue, the subscribing Lutheran churches and the Roman Catholic Church are now able to articulate a common understanding of our justification by God's grace through faith in Christ. It does not cover all that either church teaches about justification. It does encompass a consensus on basic truths of the doctrine of justification, and shows that the remaining differences in its explication are no longer the occasion for doctrinal condemnation. We agree on most things, and where we don't agree, we're not going to take pot shots at each other anymore. Notice who's signed on since 1999. World Methodist Council in 2006, the Anglican Consultative Council in 2016, the year running up to 2017, the 500th anniversary of the Protestant Reformation, the World Communion of Reformed Churches in 2017 in the run-up to the 500th anniversary. And notice what Justin Welby, Archbishop of Canterbury, said in 2016. When the Lutheran World Federation and the Catholic Church signed the joint declaration on the doctrine of justification in 1999, you resolved the underlying theological question of 1517 in a decisive moment for all churches in the search for unity and reconciliation. What's he really saying? The Reformation is over. There's no need for us to be divided anymore. We've fixed the problem. Interesting, isn't it? Notice the joint Lutheran, again, this is Lutheran World Federation. Missouri Synod Lutherans are not a part of the Lutheran World Federation because they're very strict and conservative. but this is most of the other Lutheran bodies. Notice what they said on Reformation Day, the 500th anniversary of Luther nailing his 95 Theses on the church door in Wittenberg. This is what they said. We acknowledge our joint pastoral responsibility to respond to spiritual thirst and hunger of our people, be one in Christ. We long for this wound in the body of Christ to be healed. We recognize that while the past cannot be changed, this influence upon us today can be transformed to become a stimulus for growing communion and a sign of hope for the world to overcome division and fragmentation. Again, it has become clear that what we have in common is far more than that, I got to fix that, than that which still divides us. They're pretty much saying the same thing that the Archbishop of Canterbury did, aren't they? Reformation is really over. Really over. And I want to look at the last section is repudiating the principles of our Constitution. It's in that same quote that we just read, just a little bit lower. Protestantism, stretch your hand. Country shall repudiate every principle of its constitution as a Protestant and Republican government. I want to look at some of the things that are happening. When you got married, where did you get your marriage license? Federal court or state court? Do you know why?
Because the state has.
Yeah, Chris is telling the answer. Is there anything in the federal constitution about marriage?
Nope.
No, that's why. Because the understanding at the beginning was, if it's not in the Constitution, power's in the states. We call that federalism. If you hear that term, that's what federalism means. State power. State power. Yet, today we have it mandated on the states, don't we? You got to recognize same-sex marriage instead of allowing the states to get there themselves. Federal Constitution say anything about education? Should be a state matter. We've got a federal Department of Education, don't we? Repudiating the principles of our Constitution. Now, could the federal government get into education? Yeah. How legitimately? Constitutional amendment. Constitutional amendment. That's how you add to the Constitution or take away. Health care is not in the federal Constitution. What Massachusetts did when Romney was governor there was totally within their state powers. Chief Justice Roberts found it constitutional under the taxing power. He forgot his Constitutional Law 101. If it's not in the federal Constitution, power's in the states. My brother, just younger than me, spent his whole career in hospital administration, either a CFO or a consultant and now CEO. And he says we need some type of national coordination on health care. I said, I don't disagree. But let's change the Constitution the way the founders said to change it, not at the federal bench. Another thing that really concerned me is the growth of administrative power in our country. Our Constitution recognizes three sources of power: executive, legislative, and judicial. Problem with, and there's a separation of powers, right? That's part of our civics from the very beginning. But the problem is in administrative agencies, you've got all three of those powers mingled in the same agency. You have no separation of powers.
Got one question.
Yes, sir.
How close are we to the possibility of a constitutional convention being ratified by, what is it now, 2/3 or 3/4 of the states?
I need to check on that. I don't know for sure. I need to check on that.
We're very close at this point. There are 34 that have currently ratified the call for 2/3 of the state legislatures. And Article 5 of the United States Constitution.
Yeah. You know, the Bill of Rights, well, I mean, not the Bill of Rights, but the Declaration of Independence says that, you know, we have the right to change the government. Of course, that, you know, that's not that doesn't legally govern. Our Constitution is what governs, but the principle, you know, is there. And I really think there's only two earthly solutions to the mess we're in, and I'm not in favor of either. One is a constitutional convention, the other is a revolt. And in both cases, I think we're in worse shape than we are at the end, after them than we are today. I could be wrong, I'm not God, but yeah. I'll have to look some more at that. It's been a little while since I've looked at that. Administrative power really took off under FDR, you remember. He tried to micromanage our economy. And then it piled on in LBJ's Great Society program. And so now I think there's close to 150 federal agencies. It's a mess. Then we have the living Constitution rather than originalism, or the people that are advocates for living Constitution will say living Constitution versus the dead Constitution, trying to say that the other one is no longer relevant. And the bottom line under the living constitutional, this is an idea that came out of academia into legal practice and jurisprudence in mid 20th century, and under this living constitution philosophy, what the Constitution meant when written is no longer important. So you have no stability of meaning. Federal judges, rather than amendments, change the Constitution. And I would argue, based on our Constitution, that had we not had separation of powers, I don't think our Constitution would ever have been ratified to begin with, because there was a distrust of the concentration of too much power. And you know, we've not ratified a single amendment since the 27th in 1972, the year before Roe v. Wade. We've been changing our Constitution at the federal bench. Notice what Justice Alito wrote in Obergefell, the same-sex marriage case. Most Americans understandably will cheer or lament today's decision, the Obergefell decision, because of their views on the issue of same-sex marriage. But all Americans, whatever they're thinking on that issue, should worry about what the majority's claim of power portends. They're finding rights that are not in the Constitution, instead of leaving it to the legislative process on the states, which is where they should have. It's a raw power grab, is what it is. And if they can use this here, because you see, precedent is really important. Gives them the opportunity to say, well, we need to fix this problem in our culture too. And they'll do it from the federal bench. Executive orders are another challenge. Article 1, Section 1 says legislative powers are vested in Congress. Not in the executive branch, not in the judicial branch, but in Congress. Article 2, Section 3 says the president's job is to carry out the law. So I don't have a problem with executive orders when they facilitate carrying out the law. I feel really different about them when they make law, because the legislative function is in Congress, according to our Constitution. Another way we're repudiating the principles of our Constitution. Here's some very specific attacks. The Electoral College is under attack today. That's no surprise. You've no doubt seen and heard that. In 48 states, the legislators elect electors who pledge to vote for the candidate who wins the popular vote in that state. And Maine and Nebraska have a little of a hybrid system where there's an elector for each congressional district, and they vote however that congressional district votes, And then there are 2 electors that vote for the statewide vote. So a little bit of a hybrid, but they're small states, and so it hasn't been a big problem. The reason why I believe that our founders put the Electoral College in place is they wanted whoever was president to have broad support across the country. They didn't want him to have support just in a few states with super population majorities. They didn't want that. They wanted to have broad support. And if it weren't in place, if you're going strictly on popular vote, then you would have a few highly populated states always controlling who's going to win, who's in the White House. And they didn't want that. It also prevents multiple small parties. Now, the specific attack is the National Popular Vote Interstate Compact. I don't know if you've heard about it, but if you're not, you know about it after today. It allows state legislators to ignore the popular vote for their state and elect electors based on national popular vote. Now, see, I think there's a problem right out the gate there because we've got a constitution that says otherwise. So their legislators, their electors in those states are going to vote based on national popular vote, and it takes effect only if adopted by enough states to control 270 electoral votes. 14 states and D.C. have signed on controlling 189 electoral votes. We're also seeing an attack on senators. Now senators are elected 2 per state, right? And of course, the way they were elected has been changed, and it was changed by constitutional amendment, which is legitimate. But originally, it was the legislature that elected the senators. And now it's by popular vote, in the states. But it was done the right way, changed through a constitutional amendment. There are people that don't want to see only 2 senators per state. They want proportional elections like in the House. So in other words, you would have 2 chambers of the same size. I don't disagree, Vernon. I think it is ridiculous. But people are unhappy with things, and so, we've seen the religious right. They feel like the wall of separation between church and state, and it's true. It's not in the Constitution, in so many words. But Jefferson said that the wall of separation is summarized in the Establishment Clause and the Free Exercise Clause. They will dismantle it. They want to abolish it. And Justice Thomas believes the Establishment Clause allows state governments to establish their own state churches. Well, that's the way it was in the beginning, until Madison and Jefferson's views gained the upper hand. You had that. And because it says Congress shall make no law. But that's how they're trying to pull down the Establishment Clause. And of course, we know at the end, we know that's going to happen, don't we? We know what's going to happen. Free Exercise Clause has been jeopardized by a 19th century polygamy case, in which the Supreme Court ruled that the Free Exercise Clause protects only your beliefs, not necessarily your conduct. They got that from Jefferson, by the way, in his letter to the Danbury Baptists. The Danbury Baptists had written him, congratulating him on his election to the presidency and complaining about the assessment of taxes to support the established churches in the states. He wrote them back and thanked them for their kind word and said, "Yeah, I agree with you. We can't fix everything at once." And he's the one who characterized the wall of separation between church and state as between the Establishment Clause and the Free Exercise Clause. And he went on in his letter to them, distinguishing belief from conduct, and said that the Free Exercise Clause will protect your belief, but not always your conduct. I would argue purely on a linguistic basis that exercise is more about conduct than belief. But Supreme Court's ruled otherwise, so I'm probably wasting my time and money and ink to argue otherwise. And see, where Reynolds is going to bite us is when the day comes that we have to decide, are we going to obey God or we're going to obey man? It'll protect our beliefs, but not necessarily our conduct. This is really interesting. It just happened just a few months ago. My wife called it to my attention. You know, virtually all frats, fraternities, and sororities are single sex, aren't they? And Harvard now penalizes them. They can't hold any student government positions at Harvard. They can't be captains of any sports teams if they're a member of a single-sex fraternity or sorority. This is Harvard. You know, freedom of association arises under the doctrine of the right to assemble. So it's going to be interesting to see what happens with this at Harvard. Wonder where Harvard Law is on this, by the way. I don't know. You know, the Second Amendment continues to be a very volatile issue in our culture, particularly every time we have a mass shooting. But I would argue, you know, we've got to find a way through all of this because all of the Bill of Rights amendments are important. And if Second Amendment's not important, the First Amendment's not important. The right to freedom of religion and speech and the other provisions that are there. And what I think has happened too often, in fact, there was an article, I'm getting ready to, I've been working on a response, I've got to sit down and finish it. But there was an article in Liberty magazine where a lady, I think she's Methodist, and she has a right to believe what she wants to, but she makes a very interesting statement that is a little bit surprising to me. She says that guns kill. The only way I know that a gun kills is if the gun explodes. And that's the likelihood of that is pretty low. Guns don't kill. People kill. People kill. And the thing that the church has done, we've lost our prophetic voice, I think, on this issue. Because we live in a culture that reeks of violence. I grew up without television. We didn't have money for television because my mom and dad were committed to all four of us kids having a Seventh-day Adventist Christian education. They were committed to our mom being home with us. My mom taught church school for 7 years before she and my dad got married in 1953. And so we didn't have money for, television wasn't essential. We only had money for essentials. We drove the same car from 1955 to 1969 so we could have a Christian education. That was more important to my parents. My dad had that car at work, and we lived a quarter mile from the church school. You can put up just about anything weather-wise for a quarter mile, except baseball-size hail. So anyhow, so when I look at violence, I look at it through my growing up years. And when we would go down and visit my dad's folks down in Freon in the southwestern Texas Panhandle from Amarillo, where I was born and raised, Saturday night we'd most often watch Gunsmoke. Remember? We'd watch Gunsmoke. Now there was a little bit of violence in Gunsmoke. They'd have some fist fights and come tumbling out of the Long Branch, out on the sidewalk and the street, or they'd have a duel, on Main Street, and Marshall Dillon would always come out on top on that. But and I'm not downplaying the violence there, but the violence in Gunsmoke is pedestrian compared to the violence today.
They didn't kill anybody on Gunsmoke.
Yeah.
They shot them in the arm.
Yeah, and so, we've lost our prophetic voice, and we need to be addressing the issue of violence in our culture. The Bible says, Jesus says, my coming is going to be like Noah's day. And if you look at Genesis 6:11, it says, violence, filled the earth. If that doesn't describe our day, I don't know what does. Violence filled the earth. Another place in that 6th chapter, it says their thoughts were only evil continually. Lord have mercy. We're changed by beholding. 2 Corinthians 3, verse 18. We're not talking about that. We need to be. Now this one is going to be a tough one, especially with our Sunday friends. But if God's law is not to be respected, what chance does man's law have? There's some answering. Some of my Sunday brethren got to give on the day of judgment because they've been negating God's law, which implicates man's law. We see a number of exceptions to the Fourth Amendment warranty requirement. Plain view, hot pursuit, stop and frisk, etc. I've sort of forgotten some of that. I remember them telling us whenever I was getting ready to take the bar exam in 2007, be up on your Fourth Amendment stuff because there'd been some illegal stuff going on. But, you know, you lose it, you use it or lose it. And you can't stay up with everything. But one of the things that is now that's generating a lot of interest is this community caretaking, and the Supreme Court's basically deal with it more on vehicle searches, but the way it's playing out most of the time now on a state level is somebody wonders, well, I haven't seen so-and-so in a while. I wonder are they okay? And they call the police and they go into their house and they're either okay or they're not okay, but they see a lot of evidence of criminal misconduct and they have no warrant to go in there. You know, that's the issue with community caretaking. We have marshals, U.S. Marshals, often using stingrays, which are like a mini cell phone tower that only goes out a few feet. And so if they're looking for a criminal and his call goes through that, they know he's within a few feet. Most of the time it's used without a warrant. Most of the time used without a warrant. Plus it intercepts all other calls. Go through it as well. And then my black friends tell me, there's an expression they use, driving while black. You know, I was at a meeting in Berrien a few years ago, and when Elder Don Livesey was still our union president, he asked the black brothers there's a bunch of them there. We're talking about race relations that Sabbath afternoon, and he asked how many of them had been stopped without cause, and the majority of the black men stood up. We white guys have white privilege, and we don't face those issues, but they do. January 3, 2017, AG Loretta Lynch signed an order directing the NSA. You know, the NSA is trying to capture all of our electronic traffic to make available raw spying data without a search warrant. Again, running roughshod over the Fourth Amendment warrant requirement. Bottom line is, friends, our world's getting set up for Revelation 13. Fast and furious. Fast and furious. About the last thing to happen, other than the preaching of the gospel to every ethnic group, is this. Men in responsible positions will not only ignore and despise the Sabbath themselves, but from the sacred desk urge upon people the observance of the first day of the week, pleading traditions and custom in behalf of this man-made institution. They will point to calamities on land and sea, to storms of wind, the floods, the earthquakes, the destruction by fire as judgments indicating God's displeasure because God's Sunday is not sacredly observed. These calamities will increase more and more. One disaster will follow upon the heels of another, and those who make void the law of God will point to the few who are keeping the Sabbath of the fourth commandment as the ones who are bringing wrath upon the world.
Just the opposite.
Exactly. As I said, other than the preaching the gospel to every ethnic group, this is about the only other thing left to happen. You begin to see these judgments. And they're going to point to us because you violate the Lord's day as they define it, not as God's Word defines it. Because we have done such a wholesale job of repudiating the principles of our Constitution, just like the Lord's messenger indicated. You know, I wondered as a young lawyer, how are we going to repudiate our constitutional protections? And then I read 5T 451 says we're going to repudiate the principles, and we've just done it. I could say a whole bunch of other stuff, but I've chopped a bunch of stuff just for the sake of brevity. Free exercise clause will afford us no protection. Establishment clause will mean nothing. You know, we're going to have an establishment of religion. And Revelation 13 is very clear. At the time of the Civil War, we weren't following the rule of law. Lincoln was holding people without charges. He was a trial lawyer, tried to do away with the writ of habeas. Somebody would ask me, I would say he shouldn't be on Mount Rushmore, but they didn't ask me. You know, that was our greatest constitutional crisis to date, was the war between the states. And a lady died who had nothing to do with his assassination. She was granted a writ by a justice appointed by Lincoln, Mary Surratt, and Andrew Johnson, the president, revoked the writ of habeas corpus. When does the executive branch have the authority to revoke an judicial branch document? If you don't follow the rule of law in a time of constitutional crisis, you're going to make it up as you go. And that's what they were doing. And that's exactly what's going to happen again. Because at the end, that will be the greatest constitutional crisis our country has ever faced. And because we're not going to follow the rule of law, we're going to make it up as we go, and there will be no rights for anyone. You know what's interesting to me is we live today in a world that's very secular. Our culture is very secular. And it's going to be interesting when Rome takes over and it flips, how the secularists are going to react to that. It's going to be very interesting, very interesting. I got to take my lawyer's hat off and put my preacher's hat on. I got to leave you with hope, okay? Lawyers have got to spill the good and the bad, don't we, Chris? So a client will make an informed decision, but I got to leave you with hope. Daniel 12, not 1. At that time, Michael shall stand up. You remember in Daniel 7, the judgment is seated, the books are open. Nothing happens until the judge is seated. You know, Chris can't earn a single nickel in his job as a trial lawyer until the judge is seated. And when the judge stands up, he's not earning any more either. You know, nothing happens unless the judge is seated. Judgment's over here because Michael stands up. The great prince who stands watch over the sons of your people, and there was a time of trouble such as never was since there was a nation, even to that time. We need to focus more on the last sentence, I think, than we do. And at that time your people shall be delivered, every one who is found written in the books. Friends, that sentence is going to mean a lot to us in the end, isn't it? Because God's promise is to deliver his people at the end. I have another quote. I have a quote in a different presentation. It's in the manuscript releases. I don't remember which one. But she quotes, Ellen White quotes from, let me see if I can find it right quick, because this is a powerful, powerful quote. I just feel impressed to share it with you all today as we close. I think it's in this one. Let me see here. Yeah, this is it. Let me get it up here on the screen so you can see it. The message from God to me for you is, him that cometh unto me, I will in no wise cast out, John 6:37. If you have nothing else to plead before God but this one promise from your Lord and Savior, you have the assurance that you will never, never be turned away. It may seem to you that you're hanging upon a single promise, but appropriate that one promise, and will open to you the whole treasure house of the riches of the grace of Christ. Cling to that promise and you are safe. Him that cometh to me, unto me I will in no wise cast out. Notice this last sentence. This is powerful. Present this assurance to Jesus, and you are as safe as though inside the city of God. Isn't that amazing? 10 manuscript releases, 175. That's 22 or 23 of them, the little paperbacks. Claim this promise. You're as safe as though inside the city of God. Does it get any safer than that? I don't think so. Any questions before we close? Been good to share with you. Maybe I've just overwhelmed you with a whole bunch of stuff here, but
Just a comment, I was just reading like in the last couple of days that 2 female college athletes who run track had recently lost like a meet. They ended up in 2nd and 3rd place in all of the meets, and the winner was a transgender male, and they're filing suit to have him eliminated.
you may not have heard that at the back. She said that there were 2 female track stars who placed 2nd and 3rd. They lost in more than one meet to a transgender male.
I don't think he's transgender.
No. You know, they can change their appearance. Can you change your DNA? Absolutely not. Absolutely not. Yes, ma'am.
I don't know if any of you have read the book 1984. Have you read 1984?
George Orwell? Some, not all the way through.
It's very interesting. So I read it in high school. I read it in high school.
She got the yellow.
I read it in high school. Hello, check. And anyway, so when things started changing in our culture, it reminded me of this book. So Rob and I just watched the movie on YouTube. And there are so many things that parallel what's happening in our culture. But one of the things really struck me, and in particular with transgenderism, at the end, when the main character is caught, he's defying the state. And when he's caught, they have to reprogram him. And they tell him, you will believe what we tell you is reality. And so the guy who's torturing him, and he's conditioning him, and he holds up 3 fingers, and he says, I can't remember how many fingers, and he wants the guy to tell him that he has 4 fingers. And so as he's go through this reconditioning process, I'll say to him, now how many fingers do I have up? And I'll say 3, and then he goes through the process again and again, until finally he says, I don't know, and then he says 4, when the man is holding up 3. And it struck me, that's exactly what's happening in this transgender movement. We're being conditioned to say that 3 is 4. We're being conditioned to say that male is female. And it's so odd, and the culture just steps in line. And it was very sobering to me. There are many things in that book, if you read it, that it was almost like the game plan was written out. Very, very, very interesting. But just that struck me recently about the transgender movement is we will look at a man and say, that's a woman, and believe it. Very sobering.
Yeah. It's a woman only on the surface, has male DNA, and you can't change that. By the way, as a practical matter, if you have a male claiming he's a woman and wants to use the ladies' restroom here, you can forbid him to do that, because this is not public property. This is private property. This is not a place of a public accommodation.
That's good to know, because I heard Target is like,
Oh yeah, oh yeah. That's why I almost will not shop there unless there's only that's the only place I can get it. Is because I disagree with their philosophy. Yeah.
You know the problem that I have,
Mark.
and that is the young people, like
Red.
today, is, like, how do we talk to them about this issue?
yeah.
Because there's so much they're bombarded with school and television and social media, and they begin to think this is acceptable.
Yeah. We need to keep them. We've got to get them into God's Word. We've got to get them involved in the mission of the church. As much as possible, we need them in our schools, because when I came to here to Indiana, the guy that was our education superintendent, he's since retired, and he told me that in kindergarten curriculum, they're teaching now that being gay is as normal as being left-handed or right-handed. And I'm sorry, that's a big pile of what you find out in the barn. Great big pile of what you find out in the barn. That's one of the real challenges today that we have to remember about public education. To a large degree, it's more about conveying an ideology and brainwashing.
Yeah.
Yes, ma'am.
I just kind of had a question about, well, maybe an opinion. I remember you were saying about it can protect your beliefs, but it doesn't
Reynolds.
protect your conduct.
Right,
And so
Reynolds.
that can harm us in the future. But do you think that is maybe stemming from something like maybe with like Muslims and Sharia law, or like other religions and animal sacrifice, or that kind of thing? Like, where do you think that's coming from?
See, of course, this arose. The context in which it arose is polygamy, and Mr. Reynolds was claiming the free exercise clause is his defense for being married to multiple wives. Supreme Court's between the proverbial rock and a hard place, because you remember Utah had to agree to ban polygamy before they could become a part of the country. And so the Supreme Court's looking for some type of precedent to hang their hat on. And they reached back to Jefferson's letter to the Danbury Baptist, where he distinguished between belief and conduct. And so what they were saying is, Mr. Reynolds, you can believe you can be married to as many wives as you want to, but so sad, so sorry, we're not going to give you that right. Because according to Mr. Jefferson, free exercise clause only protects your belief, not necessarily your conduct. Now, it can protect your conduct, but we're going to decide whether it's going to protect your conduct. Now, I'll be honest with you, I don't worry about Muslims and Sharia law and a lot of this stuff. I know a lot of Christians do. They're very, very concerned about it. But who are the players at the end in Revelation 13? Who are the players? It's Rome and United States carrying Rome's big stick, right? Islam is lined up somehow behind Rome.
Where you have a lady out of Fatima, that person that married.
Oh, yeah.
So that's interesting.
Yeah, the Fatima visions. Yeah. But, yeah, so, a lot of Christians are very concerned about Islam because they're out birthing us. And there's been some question about the prior president, was he born in this country or not, and, et cetera, et cetera. But anyhow, I don't want to go there. But anyhow, but they're concerned that they might get somebody that really, truly is Muslim, that was born here, into office. And, we've got several Muslim Congress ladies, right now. And so, it's not by accident. But I'm not concerned about Islam because they're not going to be a factor then according to Revelation 13. And in fact, there's in a recent, I think it was late last year, there was an article in Liberty magazine by, I believe that the writer is Muslim and lives in Canada, and he's writing about the collapse of Muslim culture. And you know, a lot of us see Muslim culture, you know, on the way up, and he's writing the opposite. He says it's collapsing. Now, he knows a lot more about it than I do, because I'm about as Muslim as most of us are here in this room, which is nothing, you know. So anyhow, I have to take what he says seriously. Yeah. Well, friends, hang on. But remember, Jesus is going to be with us always. Some people make a big deal, well, we're not going to have an intercessor. When the judgment's over, we're not going to need an intercessor, right? Because God's people are sealed. You know, he that is righteous, let him be righteous still. He that's filthy, let him be filthy still. You need an intercessor when things are still in play, right? Jesus is going to be with his people, and he's going to deliver them. And remember, just as the plagues fell on Egypt to effect the deliverance of ancient Israel, plagues that fall on the world at the end are to bring about our deliverance, the deliverance of spiritual Israel. I think the plague of darkness, the fifth plague, is there to make man search and destroy technology impotent. I can be sitting in the middle of a field, and if God covers me with his angel, it is as if I am not. So, you know, God's for us. And remember, he uses the word there in Daniel 12. Now, I know Daniel, I don't know if Daniel's a lawyer. Do you know Chris for sure? He's a government official for sure. He's a government official before. And the word shall at law means that you have to do it. But so I don't think he's writing as a lawyer, but I still like his use of the word shall. He says, and at that time, you know, at the time of trouble such as never was, and at that time, your people shall be delivered. Friends, these promises are going to be very meaningful on a very practical basis at the end. That's why we need to fill our minds with them. Like Peter says in the first chapter of 2 Peter, these promises are given to us so we might be partakers of the divine nature. I can't speak for any of you, but boy, I need all the divine nature I can get. I'm just speaking for me. I need all the divine nature that I can get. Let's pray. Father, thank you for this time that we can share together. Thank you for this time that we can be alive at all times in the history of the earth.
We pray that you will fill us with your Spirit, changing our lives more and more into the likeness of Jesus. And you will empower us to reach out to those about us so that we can see that great harvest gather. And together stand there on the sea of glass to your glory. Thank you for your promise to be with us. And let us be faithful at the task that you are pointing to us to carry out what you have asked each of us to do. Till that day when we shall see you face to face. In Jesus' name. Amen. Well, good to be with you all. Lord to be with you. Have a wonderful Sabbath and hang on, friends. We're in for a ride.
Jesus is going to be with us.